Hello. I'm doing a vlog today on the issue of Psagot Winery and the labeling case that has been brought to the European Court of Justice because there's been a lot of fake news circulating, and I think it's time to correct the record. First of all, the European Court of Justice, so everybody knows, is going to decide on November the 12th, which is very soon, whether or not EU law requires the discriminatory labeling of Israeli products as Israeli colonies. I think it's quite clear, and I think the European Court of Justice esteemed justices will agree that, in fact, no, there is no EU law that requires the labeling of Israeli goods from the disputed territories as coming from Israeli colony. That's just simply a fact. The way and the reason why this started is because the European Commission issued a non-binding notice demanding that EU states label Israeli products as such, and was touting the notice, even though it had no authority to do so, as binding. And so countries like France implemented regulations that required importers to label Israeli products from the West Bank, from the Golan, from Eastern Jerusalem as coming from a so-called, quote, Israeli colony. Now, it's important to note that there are only two questions before the European Court of Justice. Number one, as I mentioned before, does EU law require the labeling of Israeli goods from disputed territories as coming from an Israeli colony? The answer is no. The second question is, if not, are EU states free to impose their own types of labeling requirements? And I think, again, the answer is no, because there has to be uniformity when it comes to trade and import into the EU. Now, I think it's really important also to notice that what the current non-binding notice and the Advocate General's opinion, which again at the EU is non-binding, is just an advisory opinion, is advocating really is unlawful discrimination. According, for example, to the Oslo Accords, which is the international treaty that governs Israel's presence and created the PLO and governs the PLO's presence in the so-called disputed territories, both Israelis and Palestinians are allowed to live in the area, have full rights to live in the area. Israelis under the sovereign authority of the Israeli government, and Palestinian Arabs under the control of the PLO. And whatever happens in terms of a creation of a Palestinian Islamic state will be determined through final status negotiations. That is what Oslo says. And by politicizing labeling, what the EU Commission, what the European Commission is attempting to do is impose its own foreign policy through trade. And that's, I think, quite wrong. According to the International Holocaust Remembrance Alliance definition of anti-Semitism, the IHRA definition of anti-Semitism, quote, applying double standards by requiring of Israel a behavior that is not expected or demanded of any other democratic nation is discriminatory, is anti-Semitic. And you have, for example, the United Nations has declared that countries like the United States, the United Kingdom, Russia, Morocco, France are all, according to the United Nations, illegally occupying and colonizing certain territories. And yet those countries, imports from those countries, are not being treated the same. So this is definitely disparate treatment of products from areas controlled by the Israeli government, which in essence is discriminatory and anti-Semitic. Now, while the European Court of Justice is expected to release its decision on November the 12th, there is absolutely no reason to believe that it will follow the Advocate General's opinion, which in essence says that products coming from Israel, aka Jewish products, should be labeled one way, Israeli colony, but products coming from Palestinians, aka Muslims, should be labeled another way, as coming from made in Palestine. That is discriminatory on its face. In the meantime, We've had anonymous Israeli officials leaking to the media, claiming that many EU countries have simply not been implementing the labeling guidelines. So it's better policy just to ignore them. I think this is a very misleading and dangerous position to take. First of all, countries like Germany, Belgium, Spain, the Netherlands, and others have indeed been ramping up their enforcement of the discriminatory labeling policies against Israeli imports. They've been sending letters and notices to importers of Israeli goods. And second, what these anonymous Israeli officials seem to be doing is asking private companies to simply ignore the fact that their goods are being targeted for discriminatory treatment and not avail themselves of a objective court system to enforce their rights, which they have every right to do. Despite the fake news being disseminated by certain media outlets, this case will not make things worse for Israeli exporters. If Psagot Winery had not brought suit, the status quo would remain. Israeli exports into the EU from disputed territories would be labeled Israeli colony, even though there is a non-binding notice. It is not a binding regulation, and it is discriminatory, not just under EU law, but also under state law. So what Psagot's legal case does, it doesn't change the status quo, it challenges the status quo, with the aim of preventing any future legal cases against Israeli products or companies that refuse to enforce these types of discriminatory labeling. Even in the event of an unfavorable decision at the European Court of Justice, even if the judges at the ECJ decide that EU law somehow does require this type of labeling of goods coming from disputed territories, there is no way that this labeling law can then only be applied to Israel. And I guarantee that cases will be brought in every single European jurisdiction alleging the discriminatory labeling of Israeli goods. And there is no way that they can only be implemented against Israel, which is why I think the justices, in all of their wisdom, will realize the Pandora's box of consequences that will be opened should the EU allow labels to become political billboards. If there is a law that says, yes, indeed, labels on cups or products or wine should indicate everything that a consumer may want to know about that country, even if it has nothing to do with the mercantability of the product, it's going to be total chaos. Styrofoam cups from China are going to they're going to have to be labeled, by the way, China had a one-child policy. Oil from Iran is going to have to be labeled, by the way, Iran executes gays and doesn't, respect minority or women's rights. Every single country that engages in human rights violations or has any type of presence in a disputed territory, all of their exports will be challenged, and it will cause incredible chaos, which is why I believe the European Court of Justice will uphold the law, will uphold the rule of law, and say that labeling must stick to what is important for consumer protection, which is labeling the geographic location, not a politicized statement, as well as any content that a consumer may want to know in terms of the mercantability of the product itself. It is deeply troubling that Israeli government officials would, under the cloak of anonymity, leak false news and legal inaccuracies and factual inaccuracies, sending the message to the European Court of Justice that not only does it expect a negative decision, but that it's prepared to blame an Israeli company, a private Israeli company, for bringing a case not only to protect its commercial interest, but by extension the commercial interests of all Israeli companies engaged in export into the EU. And that not only does Israel expect a negative decision, but it's prepared to blame a company for exercising its right to bring a case before the French court and the European Court of Justice. So I hope that everybody now has some sort of clarity. I would encourage reading the article, the op-ed that I just published in JNS, which is correcting the record on Psagot's case against labeling. Thank you.